I'll now be discussing the Supreme Court judgment in Bhagwan Dass versus the state of Haryana. It's reported as 1987, Volume 4, SCC, page 634. Now, why this judgment is important? I think it's very, very important from the perspective that this judgment highlighted that similarity in the nature of duties is the overarching principle which should govern claims for grant of equal pay scales, or simply put, equal pay for equal work. Now, in this case, the petitioners who approached the court were appointed as supervisors on temporary basis under an adult education scheme run by the government. They claimed equal pay as compared to the regularly employed supervisors. Now what happened was, their pay was a fixed remuneration which was much lower than what regularly appointed supervisors were getting. So they claimed that their pay scales should be at par with such regularly employed supervisors. The state contended that there were differences between them. In particular, the fact that the appointment of these persons under this scheme was temporary as compared to regularly appointed supervisors in the education department. Secondly, they had not undergone a rigorous selection test, which was an all India test. Rather, these persons had been simply picked up from clusters of local villages. So therefore, they could not have been granted the pay scales of regularly employed persons. Now, this matter went to the Supreme Court. The Supreme Court most importantly held that the mode of recruitment of these persons was immaterial for the fact that they were discharging duties which were admittedly similar to regularly employed supervisors. The fact that their mode of recruitment was different could not be a factor because the state itself and consciously had chosen to restrict the mode of their selection to clusters of locally situated villages. And if the state had done something like that, so therefore, such persons could not be denied the benefits which were legitimately due to them. I think secondly, the court also laid down an important principle that the prima facie burden at the initial stage to show equal pay for equal work lies on the employee or the person who's approached the court. But once that prima facie burden is discharged, then the burden shifts to the state and the state is required to prove dissimilarity. So, thirdly, the nature of appointment, whether it's temporary or permanent, is irrelevant in determining a claim for equal pay for equal work. Now, why this 1987 judgment is important is because the Supreme Court in its recent 2017 judgment in state of Punjab versus Jagjit Singh has relied on this judgment and sort of resuscitated the principles laid down in this case, which were somewhat, in a sense, lost during the subsequent judgments of the 1990s and early 2000s.